XRP. Legal expert reveals when Ripple XRP will win the SEC lawsuit. A couple of months prior, the SEC filed a case against Ripple that is still ongoing in the court. Because of this claim, Ripple and its native token encountered somewhat of a chaotic circumstance in the crypto market. However, the SEC lawsuit is expected to end soon.
You want to win an iPhone 12, maybe a MacBook Pro? How about $500 cash? You decide. All you have to do is comment the secret hidden message somewhere in this video and leave a like on this video and subscribe to the channel so we can keep affording these giveaways.
A few specialists have effectively revealed the tentative dates. So would you say you are invigorated? So are you excited? If you're willing to know what experts have to say, then stay tuned until the end of the video. Hi XRP lovers, we are back to update you about the SEC's claim against Ripple. So right away, how about we dive into today's topic, shall we? However, before that, we would truly appreciate it if you folks would like the video and subscribe to the channel so we could continue guiding and assisting you with your crypto-related inquiries. The 22nd of December 2020 was a Black Friday for XRP as the Securities and Exchange Commission SEC charged a lawsuit against Ripple XRP and its two executives. The SEC charged Ripple for selling unregistered securities and earning an enormous sum, fairly close to $1.3 billion of cash, through the sales taken. They were charged for breaking the laws under Section 5 of the Securities Act of 1933. The result of the Ripple case will mostly rely upon whether XRP is an investment contract under U.S. securities laws, subsequently making it subject to registration requirements under the Securities Act of 1933. The U.S. High Court's decision in SEC versus W.J. Howie Co. gives that an investment contract exists when there is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. The SEC has previously indicated that Bitcoin and Ethereum are not securities because of their decentralized nature, which is a hallmark of blockchain applications. The Bitcoin blockchain is a distributed ledger that keeps a perpetual and permanent record, all the transactions and exchanges. There is no central entity that mints or circulates Bitcoin. Instead, transactions are verified and Bitcoin is mined by a progression of nodes, which is a widely dispersed network comprising of countless people across the world. Since there is no central entity whose endeavors are a vital factor in creating or distributing Bitcoin, it isn't viewed as a common enterprise with profits derived from the efforts of others. Therefore, it is outside the scope of the Howey test and isn't viewed as a security. Ripple, then again, is seen distinctively by the SEC. One of the examples given by the SEC is that Ripple, without help from anyone else, minted the whole entire supply of XRP when it was first launched. Ripple is trying to audit the SEC's interior discussions about XRP and whether the SEC actually believed it was an investment contract. Now the thing is that the U.S. Securities and Exchange Commission's claim against crypto payments company Ripple is taking significantly more time than expected, that too with no apparent reason. Both parties to the case just keep on dragging the case further and further. The community that supports Ripple is eager for the lawsuit to come to an end, and one of its most popular members, attorney Jeremy Hogan, has been sharing his predictions. Be that as it may, without a settlement, the case will probably proceed into mid-2022, predicts Jeremy Hogan. In May, Mr. Hogan said that in case the SEC's new chair, Gary Gensler, pulled back from the case and rather worked for more regulatory clearness, that would happen until the finish of that month, but sadly, that didn't happen. If we go into June with no settlement, then this lawsuit has been adopted and supported by Chairman Gensler, for better or worse. If that is the case, I predict no settlement until September at the earliest. If there is no settlement and we go to summary judgment or trial, I predict, well, heck, I don't know. Do I look like a mind reader? He added. Towards the beginning of June, Mr. Hogan shared his views on what a settlement between the SEC and Ripple Labs would look like. including the expected damages for the XRP market. Since the judge pushed discovery back 60 days, the claim time periods have changed and Jeremy Hogan has updated his forecast. So, I go back to my initial idea that no settlement will happen until the close of discovery. Could it settle before then? Yes, I just don't think it's likely. So, any settlement is likely to be after at least the close of fact discovery, and that is now early September, and even more likely to be after October 16. Consider the possibility that both parties of the case are unable to arrive at a deal. Then I believe the two main issues will be decided by Judge Torres at the summary judgment. Motions should be filed within 30 days of the end of the discovery phase, and that ought to be November 16th. Yet responses to motions and replies could push any summary to an obscure date later on. I don't see the case being decided at summary judgment until early 2022, maybe January, he concluded. The two main issues referenced above are Ripple's fair notice defense and whether XRP is a security. As a fair notice defense, the SEC has of late cautioned the court that a Ripple win would invalidate the Howey test, the benchmark that has gone under investigation with the rise of the digital asset class. Ripple has banded together with Rutgers Law School to push for change. A Ripple win on the fair notice couldn't just fundamentally affect Ripple and XRP, yet in addition, it will have an impact on the crypto environment in general and undermine the SEC. The SEC has been asserting the resource is a security because of its centralized nature. Wave, then again, has continued proposing new use cases for the ledger, which is an indication of utility. In March, the judge dropped a stunner through admitting to XRP's utility, which negates the SEC security contention. SEC Commissioner Hester Pierce, otherwise called Crypto Mother, has, as of late, clarified what is the SEC's goal when recording a grievance against a firm for an unregistered securities offering. When we think about a crypto asset as being a security, what we're doing is we're saying it's being sold as part of an investment contract. It doesn't mean that the asset itself necessarily has to be a security. It means that it was being sold as a security. Meanwhile, a new competitor led by ex-PayPal and Ripple staff has emerged. Algorand-powered 6 Clovers. This simply demonstrates how significant it is for Ripple to close this legal chapter with the SEC. The controller, notwithstanding, can utilize this feeling of crisis as influence. Talking about influence, we reviewed the last crypto crash and role of leverage or margin trading in market volatility with an eye on Ripple's XRP. Moving on to the criticism of the Ripple lawsuit, numerous spectators from the crypto and business networks have been critical of the SEC's claim against Ripple. Some concerned that it could disable a nascent industry that looks to make technology, finance, and money itself accessible to more people. Others call attention to the fact that the claim was hastily conceived, given that it was documented one day before Chairman Jay Clayton left the SEC. Indeed, just 3 of the 5 SEC officials approved filing the Ripple claim, the minimum threshold for the SEC action to continue. Still, others point out that the case doesn't appear to include any harm to financial backers, that the SEC has thought about XRP since 2013, and that XRP is a legal technology with a market capitalization of roughly $25 billion. Some contend that it would make more sense for the SEC to stand by and pursue a more clear-cut case under the Howey test in order to develop more case law on this issue. Previous SEC chairman and current Ripple defense lawyer Mary Jo White said, "There's no way to sugarcoat it. The SEC is dead wrong legally and factually. So is there a mutually beneficial outcome on the horizon? As a significant crypto case brought by the SEC, the Ripple lawsuit might altogether affect the future regulations of digital currencies, yet in addition blockchain and monetary innovation, fintech applications, which work utilizing comparable advancements. Pushing ahead, it might make more sense for the SEC to implement reasonable, estimated guidelines for cryptographic money, blockchain, and fintech organizations. Likewise, Congress could give a framework for the guideline of cryptographic forms of money and other computerized resources. However, this might be improbable in the present world of politics. For the present, the SEC is probably going to lead the way in adjusting the interests between a regulatory framework that ensures financial backers, yet is appropriate for crypto organizations trying to foster real new advancements. A reasonable administrative structure would, in a perfect world, advantage the crypto business by giving guidelines about allowed exercises. While the result of the Ripple claim is unsure, the gatherings have been occupied with settlement conversations. The recently selected SEC chair, Gary Gensler, is viewed as an expert on digital money, which he instructed about at MIT. Gensler may look into the Ripple case and any subsequent administrative system, conceivably promoting a more adjusted methodology by the SEC pushing ahead. While the SEC tries to ensure the general population and guarantee consistency with protections laws, it additionally appears to comprehend the conceivably huge advantages related with blockchain innovation. In a new hazard alert, the SEC exhorted speculation counselors, specialist vendors, and public protections trades of the advances in dispersed record advances while suggesting best practices for keeping up with protection laws. Pushing ahead, digital money owners should keep up to date on the quickly creating laws and guidelines in this space and ought to counsel experienced digital money or protection counsels with any inquiries. So guys, this is it for today. We hope that this video, one way or another, was of some help to you. What do you think is going to happen next in this SEC versus Ripple battle? Tell us in the comments section. Also, don't forget to hit the bell icon. See you in the next video. Thanks for watching.